the only one. Once we finish with the remainder of the attorneys, we can go ahead and bring in the folks on the piece.
Yes, ma'am.
Okay. Oh, good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for June 11th, 2025. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. Mr. Nunez, you want to go ahead and call our first case, please?
Yes, ma'am.
Thank you.
Calling cause number 2024 DCV 3531, Rocco Developers et al. Versus Lendark LLC. Announcements, please.
Good morning, Your Honor. Paul Grajeda for Rocco Developers, LLC, and Alejandro Rodriguez Castro.
Morning.
Good morning, Your Honor. Matthew Ormiston for defendant, Lendark LLC.
Good morning, gentlemen. We are set for a status conference. Let's see. 03. Let me see. Hold on 1 second. No. 3531. I hit the wrong one. Status. Okay. I have the notation of we may need a trial date. How about I get a status?
Okay, sure. Judge, this case was originally filed back in, I believe, 1st of 24.
Mm-hmm.
And it was filed as a TRO regarding a foreclosure of a apartment project out on the east side of El Paso.
Mm-hmm.
That part of the case, I think, is done. The property has since been foreclosed. And so I think at this point in time, it's probably the counter plaintiff, the defendant / counter plaintiff that would be pursuing claims at this point in time, the way kind of I see it.
Mr. Ormiston?
Yes, Your Honor. Paul's correct. We're still trying to figure out, because we did sell the property, and so there's been a lot going on kind of around this case, but we are in a spot now where my client is making a final determination as to pursuit or non-pursuit of our counterclaims against the plaintiff / counter defendant.
Mm-hmm. Okay, well, if I'll give you 30 days to come back to scheduling status conference. At that time, you can anticipate that either you're going to get a trial date with a mediation deadline down the road, or we'll just shoot an order sending you all to mediation to be completed within 60 to 90 days, okay?
Okay, perfect.
I'll give you that 30-day window to see if you all can come up with anything, okay?
Okay, excellent. Thank you, Your Honor.
Go ahead, are you good with that?
Yes, Judge. Thank you so much.
Have a good day.
Bye.
Thank you. You too.
Sure. Who's next?
Judge, on page 1, calling cause number 2024 DCV 3483, Gina Arias versus Ramon Lucero. Announcements, please.
Good morning, Your Honor. Gabriel Perez. Oh, let me turn it back on. Good morning, Your Honor. Gabriel Perez on behalf of plaintiff. I do see her logged in.
I'm sorry. Oh, there you are. Gina Arias. Miss Arias, are you there?
Gina, can you hear us? She's the court coordinator for Judge Bramlett, Your Honor, so she might be. Gina. If you want to, I guess, maybe come back to it, Your Honor. I guess she might be busy with court.
Bear with me 1 second. All right. Okay, we'll come back to that one. Oh, no.
Here I am.
Miss Arias, good morning.
Good morning.
Okay, so you were here on 3483, Gina Arias versus Ramon Lucero, is that right?
Yes, Your Honor.
Okay, and then I want to see in the waiting room, do we have we had any contact from Ramon Lucero, Mr. Nunez, or Miss Hernandez, if she's here? Yes.
No, ma'am.
No, ma'am.
Okay, so we're set for default today, Mr. Perez. Go right ahead.
Thank you, Judge. And Your Honor, I'll call my client, Ms. Arias.
Ma'am, would you raise your right hand, please? Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
I swear.
Thank you very much. Go ahead, Mr. Perez.
Thank you, Judge. Gina, please state your full name for the record.
Gina Arias.
And Gina, how do you know Ramon Lucero?
He was my landlord for quite a bit of years.
Okay, and the property you were residing at or renting from him was 3409 Mountain?
That is correct.
And that's here in El Paso County, Texas.
Yes, sir.
Now, we've sued Mr. Lucero on a couple of different causes of action, but primarily resulting from the poor living conditions and the breach of contract that you had with him in the lease, correct?
That is correct.
Okay, now the damages that we've requested in our petition, let me see, I believe, you could go back to that, include the rent and the cost that you incurred for having to seek a new home or new living conditions, correct?
That is correct.
And I believe the damages we've asked for are $5,500 plus attorney's fees of $2,500. Does that sound familiar?
Correct.
Okay. You feel that this is fair given the situation and what you had to go through as far as the mold and the poor living conditions?
That is correct.
All right. Thank you, Your Honor. I'll pass the witness, Your Honor.
Thank you. I don't have any questions from Ms. Arias. You have anything else, Mr. Perez?
No, Your Honor, and I've already forwarded a proposed judgment to the court.
Okay, I do have that. Let me just review something really quickly. All right. Okay, judgment is granted. I'll go ahead and sign off on the proposed judgment. I will also take judicial notice of all the documents in the clerk's file, as well as the entirety of your motion and any exhibits attached there. Thank you very much for your time. We'll go ahead and get the order filed.
Thank you so much.
Thank you, Your Honor.
Have a
Maybe
good day. Yes, sir. Bye-bye.
Thank you.
Okay, who's next?
Judge, page 1, the middle of the page, the Navy Federal Credit Union versus Naomi Lowe. No one's appeared on that one. Did you want me to call that one?
Yes, please.
Call cause number 2024 DCV 3403, Navy Federal Credit Union versus Naomi P. Lowell. Announcements, please.
I don't see anyone appearing on this cause. It is set for status or dismissal. Did we receive any contact from plaintiff in this case?
I did not, Judge.
No,
Okay.
ma'am.
Thank you very much. It will be dismissed for want of prosecution. Let me back up, Mr. Nanez, on 3593. Is there someone here on 3593?
The defendant is Miss Maria T. Cardenas, Judge. I have her in the waiting room.
Let's go ahead and bring her in.
Yes, ma'am.
And Judge,
Uh-huh.
on that one, you have the documents. I just emailed them this morning.
Okay, thank you. But where's the attorney, I guess is my question. Okay.
Miss
Yes.
Cardenas, are you there?
Thank you, ma'am. Let me go ahead and call the case. This is cause number 2024 DCV 3593, State of Texas versus, Wells Fargo Bank NA versus Maria Cardenas. May I have announcements, please? Ms. Cardenas, would you please just announce your presence for the record?
Que le digas que estás presente para el récord.
Estoy presente. Para el récord.
Okay. So Ms. Cardenas,
Good morning, Judge. I'm her daughter. I'm translating for her. I hope that's okay.
so I'll just state that for the record, Ms. Cardenas is appearing today, but she is a Spanish speaker. Her daughter is there with her. We were set for a default hearing. Have we had any contact? I see we received an order on May 20th on the proposed default, but no one has appeared. Can someone tell me if plaintiff's counsel opened the notice for today's hearing?
Morning, Judge. I see that plaintiff's counsel Thomas Sellers opened the notice on May 16th, 2025.
Thank you very much. So let me see, there's people coming in into the waiting room. Okay, and just so I'm clear, there's no one here on behalf of Wells Fargo Bank? All right, not seeing anyone appearing on behalf of plaintiff, the court is going to deny the request for default, obviously, and then dismiss for want of prosecution as well for their failure to appear.
Excuse me, Your Honor. This is Paula Pitter. Did you just call Crown Asset Management
No, ma'am.
versus? Okay, sorry. Thank you.
Are you here on behalf of Wells Fargo Bank?
No, Crown Asset, but I wasn't sure which one you had called because I just logged in.
All right, thank you. So
Thanks.
cause number ending 3593 is dismissed. Interpreter, well, I guess I can tell. Señora Cárdenas, su caso, oh, I don't know how to say dismissed, is dismissed.
No lo van a tomar, mami, está dismissed.
Thank you very much. That case is closed. I'm going to remove you from
¿Por qué?
Mami, no te está diciendo. Sorry about the interruption. I'm just translating for her. Dice que no llegó nadie del banco. Van a quitar los cargos contra usted.
Thank you.
Thank you. Have a good day. We're adjourned. Thank you, ma'am.
Thank you.
Okay, who's next?
Judge, did you want to hear the bottom of page 2 of the Franz Pierre, or do you want me to skip that one for now?
Let's see who is here. I see Mr. Castañón, and I think he's on 3836.
Yes, ma'am. I have several ready for you.
Okay, let's go there so we
Okay.
can.
Judge, on page 2, the second one, calling cause number 2024 DCV 3288, Capital One Auto Finance versus Jesus Satarian. Announcements, please.
Your Honor, this is Ryan Sheets for the plaintiff, Capital One Auto Finance.
Bear with me. I thought we were on Mr. Castañón's case. Hold on one second. Good
I'm
morning.
sorry, Judge, I apologize.
That's okay. Let me get to this case. Good morning, Mr. Sheets.
Good morning.
Okay, you all filed. Well, you may proceed. We're here for a writ of sequestration.
Yes, Your Honor. This is a writ of sequestration on a 2017 Ford Mustang where the note was executed on April 3rd, 2023, and the first payment was due on May 18th of 2023, and that first payment was never received. So Capital One sent their acceleration demand on August 2nd of 2023, and then my firm was employed and sent their debt validation notice on March 13th of 2024. So at this point, the loan still has the full principal amount of $24,705 left on it, and the car only has a fair market value of $12,000 at this time. So we are moving for a writ of sequestration at this time to take possession of the vehicle and limit the damage.
That is granted. I was just going through my emails to see if I had any documentation on this case. I do not. So if you would please forward any orders or other documentation, just forward it to Ms. Hernandez's email and I'll sign off on it.
Yes, Your Honor. I'll get that to you right now.
Thank you very much. Have a
Thank
good
you.
day. If you don't have anything else, we're adjourned.
You too.
All right, Mr. Castañón.
Yes, Your Honor.
Good
morning, Your Honor.
Good morning. Let's go there. Calling cause number 2024 DCV 3836, Barbara Portillo versus Selena Ortiz. May I have announcements, please?
Felix Castañón from Ms. Barbara Portillo. We're ready, Your Honor.
Your Honor, Mark Chisholm for defendant Selena Ortiz.
This is so weird. On the docket, it shows you, Mr. Castañón. I saw your entry, but it shows you as counsel for the defense.
So, Judge, on that one, my paralegal, but it's on me. I accidentally filed my notice as lead counsel for the defense, and Mr. Chisholm and I were able to discuss that. And
Yeah.
we decided I'm not for the defense, but for the plaintiff. So I apologize for that.
No worries. I just got confused because I thought, okay, so.
Yeah.
It
was quite a shock.
Saying good afternoon. It's good morning. It's good morning. We were set for a dismissal hearing, but how about you all give me a status? Yeah, I think we were here on a scheduling status conference on May 14th, so that's why we're set for dismissal because Mr. Huerta had not appeared. That's what it was.
That's correct,
Yeah.
Your Honor. Go ahead, Mr. Chisholm.
Judge, yeah, I had appeared. My adjuster thought we had the case settled, but apparently we do not. So I think, and then Mr. Castañón has appeared as lead counsel.
Okay. So you all want to
We
try?
haven't done anything because we thought we had the case settled. So we need to do discovery.
Okay, so that's fine. I'll give you a trial date a year out. Myrna, I may have misplaced your schedule of civil trial dates. Might have been a casualty of my pozole from Sunday. Miss
What
Ben,
month?
so I'm thinking a year out. We're probably, I think, April or May of next year, unless you all are asking for a shorter timetable. Could also do this. We could do a mediation order in 90 days if you think you might be close, but if you're far apart, we'll just get you your trial date.
Judge, I would defer to Mr. Chisholm.
Yeah, I think we do a trial date and I'll go back and see when maybe I'll just go ahead and mediate, but we can get the trial date and then I'll get back with my adjuster.
The scheduling order will have a deadline. Your final civil pretrial is the day before that is your deadline to mediate. Myrna, do we have a date?
April 17th, 2026, Judge.
Okay, that'll be the date. We'll get you the scheduling order. If you all will sign off on it, fill it out, pick your mediator. We'll get you your dates. Anything outside of those dates, just let us know via email with your filed pleading if you need a hearing outside of those dates, okay?
Yes, Your Honor.
Thank you very much. Have a
Thank
good
you, Your Honor.
one.
You
Bye-bye.
too, Judge. Good seeing you.
See you too. All right. Who's next? Miss Bennetson, you're here on 0100, is that right?
Yes, Your Honor.
I'm sorry, Judge, I was muted. Do you want me to call that one, Judge?
We're a little early. Let's go ahead and Mr. Casañon, do you have something else? Want to make sure we.
No, Your Honor, I'm signing off. I was just.
Oh, no worries. I didn't want to miss you on the docket. Ms.
I'm out.
Bennetson, I just want to wait till the actual time since it's a default. So we're going to take care of a couple of things before we get to your case.
All right, sounds good.
Thank you. 3405? 3405, Miss Pitter.
Yes, ma'am. Everyone's ready.
There.
Yes, Your Honor.
Calling cause, I got it, Mr. Nunez. Calling cause number 2024, DCV 3405, Crown Asset Management LLC versus Nathaporn Clinrit. May I have announcements, please?
Yes, Your Honor. We filed a motion for default judgment.
And may I have your name, please? Announce.
Paula Pitter for plaintiff.
Thank
Your
you very
Honor.
much. Is anyone here on behalf of defendant golly, I need my glasses. Clinrit? No one by that name in the waiting room. Mr. Nunez, have we received any contact from that individual?
No, ma'am.
Okay, now, Ms. Pitter, I'll hear your default.
Yes, Your Honor. So this account was originally a FinWise Bank account. It's for a loan which was opened on July 18th of 2022. Last payment was received on December 30th of 2022. We received the last payment of, I'm so sorry, Your Honor. Give me 1 second. Okay, so we received the last payment in December of 2022, and the account was charged off in the amount of $1,881.71, which is what we're seeking today, Your Honor, plus court costs and post-judgment interest. We did also file the motion for default judgment with the certificate of last known address and the DOD certificate as well, Your Honor.
Anything else?
That's it for now, Your Honor.
The court has reviewed your motion for default to include the exhibits attached, so we'll admit those for purposes of this hearing, as well as taking judicial notice of all the documents in the district clerk's file. We'll go ahead and grant your request for default judgment. What I did not see was your proposed judgment, so please submit that so I can sign off on it and and file it with the papers of the court.
Okay, we'll do that as soon as possible, Your Honor. Thank you.
Thank you very much. If you don't have anything else, you are excused.
Thank you so much. Bye-bye.
3622, I believe Mr. Hassel was here. Is he gone?
Yes, ma'am. No, I just saw him here a second ago. Yes, ma'am.
Okay, Mr. Hassel, let's call yours really quickly, okay? This is 2024 DCV 3622, Cesar Sanchez and Evangelina Sanchez versus Blanca Orcasitas and Accountable Pro Bookkeeping and Taxes LLC. May I have announcements, please?
Good morning, Your Honor. This is Daniel Hasso on behalf of the lead attorney for the plaintiffs, Mr. Ansel Escobar.
Okay, and doesn't look like we should have anyone here. It's a status dismissal hearing. I show this was filed back in August 2024 and doesn't look like anyone's been served. What's going on, Mr. Hustle?
Yes, so I apologize about that, Your Honor. We kept extending the answer deadline and, waiting off on service because we were trying to settle with the defendant's original attorneys. And we went back and forth. It fell through, the settlement fell through, and the attorneys withdrew from the lawsuit. So now the defendants are no longer represented by anyone. And so now we are in the process of attempting service. We attempted service through the defendant's registered office, the Secretary of State. When we attempted that service, it was vacant, so we weren't able to go through that avenue. We just recently, once again, attempted service through another address listed for the registered agent. That hasn't come back yet, and we're just going to keep attempting service a couple of times to see if we could get it through one of those addresses. If not, we'll do a motion for alternate service. Is there a certain amount of attempts you want us to make before we do that motion?
No, sir.
Okay, so that's kind of where we're at right now. We're in the process of getting the service done, and I'm gonna kind of try to speed this along because I know it's been kind of delayed for a while.
Dormant basically for
Yes.
about 9 months. So I'm going to give you 30 days reset on a status dismissal hearing. Okay?
Okay, Your Honor.
Thank you very much.
I appreciate that.
Sure. Thank you.
Thank you. May I be dismissed?
Yes. Have a good day.
You too. Thank you.
All right. Miss Benson. We're just about there. Let me take care of yours, and then we're going to bring in Mr. Franz Pierre and Miss Felix. All right, this is cause number 2025 DCB 0100 Vanderbilt Mortgage and Finance Inc. versus Veronica Perez. May I have announcements, please?
Yes, this is Rhonda Bennettson for Vanderbilt Mortgage and Finance.
Bear with me 1 second. All right, anyone here on behalf of Veronica Perez? Mr. Nanez, Ms. Hernandez, anything from a Veronica Perez on this case?
No, ma'am.
No, ma'am.
Thank you very much. There's no one with that name or in the waiting room. Ms. Bennettson, you may proceed on your default.
All right. This is plaintiff's motion for default judgment and for issuance of writ of possession. Along with our motion, we've got a copy of our liquidated damages attached as an exhibit, the retail installment contract attached as an exhibit. The defendant, Veronica Perez, was served on February 27th via personal service. We have our certificate of last known address attached as an exhibit, non-military affidavit attached as an exhibit, and our attorney's fees affidavit attached. We are requesting to foreclose on our security interest in the manufactured home. We are requesting a writ of possession and a judgment in the amount of $20,137 even. Pre-judgment interest, post-judgment interest, attorney's fees, and cost, Your Honor.
Okay. Anything else, Ms. Bennettson?
No, Your Honor. We just ask that all these be admitted, all our exhibits. And I do believe there should be a proposed order for you.
I was just looking for that. The court will admit all the exhibits attached, also take judicial notice of all the documents in the clerk's file. Your request is granted in terms of the default and the issuance of the writ. So I did not see, just going through my emails, any of the conforming, any of the related documents. So if you'll double check, maybe Myrna might have them if you just send them. So, but that is granted. So
okay.
Thank you very much.
Thank you, Your Honor. May I be excused?
May. Have a good day.
Thank you.
Okay, let's bring in Mr. Pierre and Miss Aguilar and Mr. Beltran. Are you there? You've been waiting patiently. Thank you. Okay. Good morning.
Good morning, ma'am. How are you?
Well, thank you. Is everyone ready to get started?
Hold on. I'm gonna finish setting up.
Actually, while you're setting up, I think we have one. Is cause number 3192? Has that already been resolved?
No, Judge, and there's no one in the waiting room.
Yeah, let's go ahead and call that very quickly, please.
Yes, ma'am. Calling cause number 2024 DCV 3192, Sarah Garcia versus Jose Sierra Jr. Announcements, please.
The court does not see anyone appearing either on behalf of plaintiff or defense. Have we received any communications? I know that they were supposed to be resolving this, but now they're not here. So anyone reached out to the court, either Mr. Carter? I don't see another attorney on there.
No, ma'am.
No, ma'am.
Thank you very much. Then the case is going to be dismissed for want of prosecution for their failure to appear. Thank you very much. Okay. Mr. Pierre, are you ready?
Yes, ma'am, I am.
Okay, let me go ahead and call the case.
Yes, ma'am.
Cause number 2025 DCV 0542, Franz Pierre versus Claire Shamblin, Caton, Sanel Van Wyck, Mary Aguilar Felix, and McCarthy Holthus LLP. May I have announcements, please?
Yes, my name is Franz Pierre. I'm the plaintiff in the case.
Thank you, Your Honor. Hector Beltran on behalf of the defendant, Mary Aguilar Felix.
Good morning, counsel. Let me just I have so many hearings this morning. I have a lot of stacks, a lot of piles here of stuff. Let me get your pile here.
It's also on page 3, Judge.
Okay. Well, I was on page 3.
It's on page 1 and 3.
We are set on Mr. Beltran's motion to dismiss. Mr. Pierre, let me pull your case up. Hold on a second.
Ma'am, may I ask, we continued our case from about maybe 2 months ago, when there was the denial of my injunction. And then there was also a couple other things that were pending. But I just want to put this up front. You're the judge, and I'll let you direct whichever way we go.
So I am going to direct the way we're going, and we're going to hear Ms. Aguilar's motion to dismiss today.
Yes.
I understand you have filed maybe a couple of things requesting, I think, let me see. Where is it? There was a request to direct.
Rent. Yes, ma'am.
All right, that is not set today. We are going to set that for hearing if that's what you're requesting. However,
Yes.
today we are solely set on the motion to dismiss and a scheduling status conference. I also know that the defendant LLP has filed an answer now. And
Yes,
so I think it was, all of this has kind of been in the last few days, so I don't know that they would have received notice to be here. I'm here
Yes.
to hear Mr. Beltran's motion. You may proceed, Mr. Beltran.
Thank you, Your Honor. May it please the court, Mr. Pierre. Your Honor, we filed a motion to dismiss under Texas Civil Practice and Remedies Code, Chapter 13, for a frivolous or malicious cause of action brought by Mr. Pierre against Mary Aguilar Felix. I want to be clear right up front. Mr. Pierre brings up a valid point that the Virginia divorce decree has yet to be domesticated in the state of Texas. That much is true. And perhaps that grants Mr. Pierre a right to seek an injunction to stop the sale of the property or something along those lines. What it does not do is give him a right to sue the realtor that he hired and contracted with to sell the property in the first place. And the reason we're here is because Mr. Pierre is suing everybody, anybody and everybody who touches this property under the false premise that somehow the Virginia court had no jurisdiction over him. He's trying to relitigate a property division that's contained in a perfectly valid Virginia divorce decree, of which he was most definitely a part of which he most definitely had an opportunity to plead his case, and which resulted in a decree that included a division of property that included his rights under the decree to buy out his now ex-wife, Miss Van Wyck's equity interest in that property, or if he did not do that by a date certain, to list the property, and once sold, to receive 50% of the proceeds of the sale of the property after paying off the underlying note, which is the new entity or the law firm that he has recently sued because they stopped foreclosure, which I find interesting. But apparently Mr. Pierre wants, I guess, the foreclosure to proceed. Regardless, we're here about Mary Aguilar. And Mary Aguilar originally was hired by both Mr. Pierre and his now ex-wife, Miss Van Wyck, to serve as the property manager. After the divorce was concluded, they then both, in October of last year, executed a broker listing agreement, which gave Miss Aguilar the right to be the broker for the sale of the property. And pursuant to that agreement, she has proceeded to list the property for sale, has secured a contract for sale, and this sale, by all intents and purposes, was ready to go through until Mr. Pierre put a stop to it by bringing these causes of action against various people. As for Mary Aguilar Felix, what he's bringing are three causes of action. One that is for something he's made up out of thin air called something. I need to look it up. I don't even understand what he's saying, but all right, Judge, let me get to it. So the first one he's brought up is the unauthorized aiding and abetting unauthorized enforcement of a foreign judgment. There is no such thing as an unauthorized enforcement of a foreign judgment under Texas law. And if there's no underlying tort, you can't aid and abet somebody in violating some legal obligation if that legal obligation doesn't exist. He's sued for negligence and gross negligence, but claims that the duty that Mary Aguilar has violated is a duty to follow Texas law. We all have a duty to follow Texas law. And so I don't understand how that's a duty that's owed to Mr. Pierre. So duty to have a negligence or a gross negligence claim, you've got to have a duty, you've got to have a breach of that duty, that the breach of that duty must proximately cause damages, and you must have incurred damages. Mr. Pierre goes 0 for 4 on that. There is no duty. There is no breach of the duty because the only duty that he's claiming she has is not to enforce a foreign judgment, which she's not doing. She's trying to sell a house that he contractually entered into an agreement with her to sell that house. There are no damages. His claim is that by trying to sell the house, somehow his property rights have been interfered with. There's no sale. I don't understand where he has been damaged. He's claiming that she has somehow clouded title. Well, he just filed the lis pendens clouding the title to the property. And so Miss Aguilar has done nothing of the sort. She's just followed the contract that he entered into an agreement with her. The last thing is his claim that she is somehow tortiously interfering with his property rights. And again, there is no interference with anything. All the actions that she's taken in this case have been authorized by him and Miss Van Wyck and the Virginia court, I might add, in listing this property for sale, which she has done, securing a contract for sale, which she has done. And that sale is now stalled pending a couple of things. Most importantly, the domestication of the judgment from Virginia, of which Mary Aguilar has no part of. She's not a party to that litigation in Virginia. She is a third party, innocent third party, who's been hired by Mr. Pierre himself and his ex-wife, Miss Van Wyck, and the Virginia court who entered the divorce decree to sell the property. And so all we're doing at this point, and we're just trying to get Mary Aguilar out of this. She's being forced to incur a lot of defense costs in this case. And she's being chat GPT'd to death with just responses that are coming out within an hour or two after motions are filed, referencing case law that may or may not support the actual position that Mr. France is trying to claim. All on, by the way, on the Texas taxpayers' dime, as well as on the dime of El Paso County residents. Mr. Pierre has yet to identify where he's actually living right now. He has not stated on the record where he can be served with process. And if nothing else out of today, we would like that, because I do know that if and when his ex-wife, Miss Van Wyck, gets around to domesticating the judgment, or Mr. France could domesticate the judgment on his own if he so chooses, service of that foreign judgment is going to have to take place. And so we would like to know where Mr. Pierre is residing right now and where he can be served with process once that foreign judgment is domesticated and the sale can be completed. So at this juncture, Your Honor, we don't foresee that there's any possibility for Mr. Pierre to succeed on any of the claims that he's brought, mainly because they don't exist at law. The facts do not support his claims. And again, we're only talking about Mary Aguilar. He's suing his broker, who he hired to sell the property, and he's suing the broker because she's selling the property. And it's a difficult hill for Mr. Pierre to climb on this one. I don't foresee that there's any possibility of success. I can go over the exhibits that were attached to the motion, but they are there. You will see a certified copy of the deed that he signed, showing that he and Miss Van Wyck are the owners of the property. Underlying all of this is Mr. Pierre's claim that this is somehow his separate property. Attached as exhibits to the answer filed by the law firm that he recently sued are copies of the note and the deed of trust on the property, both of which signed by both Mr. Pierre and Miss Van Wyck, because the property is owned by Miss Pierre and Miss Van Wyck, or Mr. Pierre and Miss Van Wyck. I've attached in the motion a copy of the listing agreement of October 23rd, 2024, in which Mr. Pierre very clearly signs along with Miss Van Wyck, and also provides his initials on each and every page, showing that he has read and understood the listing agreement. And so at this time, Judge, we're just trying to get Mary Aguilar out of this case. She does not belong in this case. She's being forced to defend herself. She's being forced to incur costs against somebody who I don't know what Mr. Pierre wants at the end. He's getting money out of the sale of this property, and now he now wants it to be foreclosed upon. I don't understand what he's doing. I don't understand the end game for this, other than trying to stick it to the Virginia court and the judge who hired or appointed Ms. Shamblin to act as an officer of the court. I think one of the things he's trying to do is take a $350,000 judgment against the Virginia court in this case as well. And so these are wild accusations, wild claims. He already has another case pending in El Paso County that predates this one, involving the same.
Mr. Benson, on that note, because I did review your pleading, I looked up the 2024 DCV 4765. It appeared to be dismissed on May 1st for the party's failure to appear. So that was the only little note I had there. But I understood that from I think maybe the last time we were here, that case was still pending. Okay, go ahead.
Okay, I stand corrected on that, Judge. This is the only case pending in El Paso County now. And so for those reasons, Judge, in the reasons stated in the motion, we would very much like to have Mary Aguilar out of this case. Mr. Pierre is free to proceed against the Virginia court and against his ex-wife. I suspect that the law firm that he's now sued will likely file a motion to dismiss in the near term as well. Like I said, the one place where Mr. Pierre is correct is that there needs to be the domestication of that foreign judgment. Mary Aguilar has no play or say in that or why that's happened or why that hasn't happened, why that's yet to happen. Mary Aguilar has no just has nothing to say on that.
I see the request for attorney's fees, but there is also a request for sanctions. What is your proposal for sanctions?
On that, Judge, I did file an attorney fee affidavit. The sanction would be just simply the amount stated in the affidavit, reimbursing Mary Aguilar for the attorney's fees and costs that she's incurred defending herself against what we believe are highly suspect claims.
Anything else, Mr. Beltran, for now?
At this juncture, no, Your Honor.
Mr. Pierre, you may proceed with your response.
Yes, ma'am. Thank you so much for the opportunity to give an update on the last case and also to allow me to have this come before you. One thing, there's several key factors I think it's important to know and to highlight. This case is centered on Texas law that mandate that foreign judgments are not enforceable until domesticated. They are not enforceable until domesticated in Texas. This deal with foreign judgment must be authenticated by within Texas. That means any action based on a foreign order that is taken and enforced in Texas is breaking that law. Now, Mr. Please, Beltran? I'm sorry.
Beltran, his name is Beltran.
Mr. Beltran I'm glad he has conceded that the Virginia order, not only my divorce, but also the order that appointed Ms. Claire as a commissioner of sale in Virginia, her order has not been domesticated here in Texas. I just wanted to highlight that. The other thing my opponent, Mr. Beltran, bring up is a contractual agreement between myself and Ms. Aguilar. It's been several years that we have an ongoing contract, and that contract is between me and Ms. Aguilar as the property manager. I've attached several communications that she only communicates with me. Yes, the property is, it is still titled under both our name, but the contract is with me. For the last several years since we've had this contract, all communication goes through me. Prior to the contract that you see to sell the house, as Mr. Beltran has mentioned, I was sanctioned by the court in Virginia to sell this property. As my agent in Texas, I spoke with Miss Mary and asked her, hey, can you sell this property for me? Because she was already managing the property. She said, yes, we had come to an agreement that 1% is what she would work for. However, during a show cause in Virginia, the judge called Miss Mary and asked her information about the property. During that conversation, ma'am, Mary asked the judge to change her percentage. After that hearing, because she, in my opinion, violated our contract and agreement that it would be at 1%, Now it was a higher percentage. That same day, I sent her an email message, which is attached, that canceled all of our contractual agreements. So the contract that Mr. Beltran is discussing is no longer active because on that same day, I dismissed her from her service. However, Miss Mary continues, even though she received the even though she received notice that she's no longer the property manager, she continues to collect the rent. At this point, she would not have that ability to do that because our contract is over. Our relationship is over. All these foreseeable actions that she has taken is in violation of our contractual agreement that it's over. Mary continues to enforce the Virginia order by collecting the rent every month. However, that same rent is being held in place through escrow without sending the money to the bank. So that action is against my property rights. Another key concern that Mr. Beltran brought up that I must address is the idea of confusing the issues between what is required by law in Texas and their action and their activities. There's a lot of things that was said about me that I believe that is incorrect. However, I think it's important to keep the facts as facts. We had a contractual agreement that was canceled. She continues to have interaction with the tenant. She does not have a signed contract. So nowhere has Mr. Beltran provided you a contract that has Sanel's signature on it prior to having this contractual relations to collect the rent. He has not provided that. Therefore, the argument that Miss Aguilar is working for me and Sanel, who's not here to say anything, he wants you to believe that Miss Aguilar continues to act as if she has a contract for me. Now, there's a lot of things that happen in Virginia, which were very bad for me and painful, but I don't want to talk about what happened in Virginia. However, the Virginia order has not been domesticated by Texas law in order for it to be enforceable in Texas. There are several case laws that I would like for you to consider, and when you're making this this judgment to dismiss this case, and I'm glad that Mr. Beltran has says that not to dismiss the case, but to dismiss only Miss Aguilar out of the case. That was not part of his. Maybe this is an amendment, but that was not part of his argument. I would like to state that Texas courts has consistently refused to validate actions based on undomesticated judgment. I have shown that Ms. Aguilar has taken action against me, against the property, and against our contractual agreement.
And your position is that there is no contractual agreement, right?
So there is none.
Okay.
But she continues to act as if there was, by continue to collect the rent, by continue to communicate with the renter, And she believes that under she has the contract to sell the house, which
Mr. Perez, let me ask you, did you take any action in the Virginia court to stop Ms. Aguilar from proceeding on your contention that there is no agreement?
Miss Aguilar is in Texas, and I cannot take any action against someone that is against the jurisdiction. It'll be very difficult to do, just like it is very difficult for Miss Aguilar to act on an undomesticated. So the answer, ma'am, no. I did not take any action in Texas, excuse me, in Virginia against Miss Aguilar and her action that she's taken in Texas. So this is the case that I brought in Texas because Ms. Aguilar is in Texas and this jurisdiction is in Texas, and her activities were done on Texas against a property that is in Texas. So this case, may I continue, ma'am?
Yes, please do.
Okay. Tortious interference with property rights. When you look at Pulley and Koff, Texas case law is clear that such interference, especially based on unauthorized conduct, Mary believes, or excuse me, Mr. Beltran representing Mary believes she has the authority. And you have in front of you a document from me, not a document from Ms. Van Veek that she has in acting on her behalf. But this document shows that she doesn't have authority to act on my behalf. There is also the idea on the listing agreement, and it is misplaced. Ms. Aguilar's subsequent actions, such as collecting rent, collaborating with Caton, were carried out after her termination. And that can be shown on Jones and versus land development. Her activities continues to be against my property rights, even though she was terminated. Texas law prohibits enforcement or actions on us on an undomesticated foreign judgment. As Mr. Beltran has greatly shown, that he believes the continuation of Ms. Aguilar acting without my authority, which was terminated, is valid, which is not. The facts are the facts. Continue to facilitate a sale of the property is an unforeseeable action against Texas law. So, in terms of the sanction, Civil Code 10.01 is without merit. Sanctions are appropriate only where claims are manifestly frivolous or malicious. I have no malicious thoughts or issue with Miss Mary Aguilar. As a matter of fact, ma'am, the fact that I called Miss Aguilar to be the realtor prior to her testifying in court against me, we had a good relationship. And my point too that I also want to make on this category is that because I've had good relations with Mary, I wanted Mary to have first dib on selling the property and get the commission. I wanted that for Mary. That is clear. However, when she testified against me,
Mr. Pierre, let me stop you right here just for a second, because maybe it's something that is kind of intrinsic to a self-represented litigant as yourself.
Yes,
you are
ma'am.
arguments, in other words, your advocacy is there, but if you're asking me to consider anything that you're saying that is not attached as an exhibit, as evidence, then I'm going to swear you in. So I need to know if some of the things that you are proffering, which are outside of your written motions or responses, if you're offering that in terms of what you would like me to consider, so you're talking about your relationship with Miss Aguilar and things that happened in Virginia. If you are offering those to the court as evidence, I'm going to swear you in.
No, ma'am. My document that I've provided you as opposition, which highlighted the cases, which I highlighted the contractual agreement that I have, that I had with Miss Mary was terminated. So her action is unauthorized. And lastly, what I wanted to say, ma'am, is that the case is a clear-cut case. I'm not doing anything malicious. I believe her activities are unauthorized. And her unauthorized activities against a foreign order that has not been domesticated in Texas is the reason why I believe this case should be dismissed.
You're in agreement with the dismissal?
Oh, ma'am, I'm sorry. I mean, to dismiss the motion.
To dismiss?
Yes, ma'am. So let me make sure I said. I would like, what I'm asking the court is based on the facts that we do not have, she does not have authority. And also the other issue is they have not showed where they have the authority from Ms. Van Veek either. He said it. I did not. He said Miss Mary was acting on myself and Miss Van Veek's order or agreement. However, he is not proving that to the court either, ma'am. In short, what I've shown you, ma'am, is my opposition. Ask for them to ask to dismiss the case. My opposition is that she's behaving in a way that is against my rights and against Texas law. That's all I have.
Thank you, sir. Mr. Beltran, do you have anything else?
Your Honor, briefly, the termination email that Mr. Pierre seems to be referring to is attached as Exhibit B to his opposition to the motion to dismiss. It's dated October 21st, 2024. It states, writing to inform you that as of today, you are no longer the property manager for the property in Horizon City, Texas. If you look at Exhibit C to the motion to dismiss, it's the listing agreement that's dated 2 days later, October 23rd, 2024. And on page 12 of 13, it very, very clearly has Mr. Pierre's signature, and it very clearly has Ms. Van Veek's Pierre's signature. And so, again, the reason why we're bringing this motion is it is frivolous. The documents upon which Mr. Pierre is relying to justify suing Mary Aguilar are on their face counter to his argument. He's claiming that he fired her. And then when very clearly, well, even if we were to say, okay, we agree, you fired her on the 21st of October, he very clearly hired her to sell the property on October 23rd, 2024. And we're not here, our motion to dismiss and his lawsuit against Mary Aguilar right now has nothing to do with her actions in terms of acting as a property manager. It's about her trying to sell the property. And so all his claims about, well, she's holding rent payments and stuff like that, that's not part of his claim. His claim is that she's interfering with his property rights. She's trying to sell the property, and she doesn't have a right to sell the property. Well, very clearly she does, and he very clearly gave her that authority. And so for those reasons, again, Judge, the chances of Mr. Pierre succeeding against Mary Aguilar on any of his claims are at best remote. And that meets the definition under Texas Civil Practice Remedies Code, Chapter 13, of a frivolous, and it's not frivolous and malicious, it's frivolous or malicious. It is a frivolous lawsuit. His own evidence runs counter to what his claims are based upon. And for those reasons, Mary Aguilar needs to be out of this case, Judge. It's ridiculous that she's in it.
Okay.
May I respond, ma'am?
Briefly, please.
The email was sent on the 21st. What is not there is I received this document from Mary on and around 15th of October, when we had an agreement to sell it at 1%. So when she testified, it was after.
Your Honor, at this point, he's testifying. He's not under oath.
Correct. So, Mr. Pierre, I need you to understand that when you are proffering the facts that you would like me to consider,
Yes, ma'am.
If that is not apparent from the face of the exhibit, which I'm assuming there's no objections, I'm not hearing any objections to exhibits from either side, that I am not going to consider it if it's coming directly from you as evidence. If you want me to consider it, I am going to swear you in.
Yes, ma'am. I would like to be sworn in with
Raise
the
your right
limited.
hand. Do you swear or affirm that any testimony you provide today will be the truth and the whole truth?
Yes, ma'am, I do.
Very much. You were saying a limit, what? Limited what?
It's okay, ma'am.
Go ahead.
What I was saying before is that this contract was sent to me earlier that day. The contract that you have in front of you, this contract from Miss Aguilar, if you look, I can't remember the page, it would say sign under duress. I do not, let me see if I can pull it up, ma'am, to give you exactly which page.
Mr. Pierre, I'll help you in the court on this. The first page of Exhibit C to the motion to dismiss does have at the bottom, I'm under duress.
Ma'am?
Yes, sir.
During this time, I had a problem with the judge, and it brought up a lot of bad things during that time, to the point that right after I signed this, I was forced to sign it. There is a contract between Mary and I that does not have all of the judge's changes on it. What you are seeing is that the contractual agreement that I had with Mary was brazenly changed by the judge. And I completely disagree, and my PTSD took on, my anxiety took on. Even right now, just thinking about this whole thing, what you're seeing is not the contract I had with Mary. The contract I had with Mary did not have all of this rewritten all over it. And page 2, you will see that the judge changed the percentage. That's not the agreement that I had with Mary. However, I was forced to sign this. And that's why I said I am signing under duress. After the judge saw that, he put me in jail. So the idea that this agreement is what Mr. Beltran wants you to consider as a document that shows she's acting on our behalf, or my ex behalf, is incorrect. Another idea that Mr. Beltran is bringing up, and I'm glad that he finally recognized that Miss Aguilar was terminated on the 21st. All activities after that should never have occurred. So I signed this under duress and against my will, and I served time in jail for that. So I kindly ask that you consider the document that he's showing, which was signed under duress, should not be taken your decision should not be based on that. I kindly request that. Can I have a minute, ma'am?
Yes, sir.
Thank you, ma'am. I just had to take some meds. This document is bringing back a lot of bad memories.
Mr. Pierre, I stopped your video. If you would, please start it. Okay.
I just needed to take more meds. This document is just bringing a lot of bad memories.
Anything else, Mr. Pierre?
That's all I have, ma'am.
Mr. Beltran, did you have any questions for Mr.
Your Honor, I do have a few questions for Mr. Pierre. Mr. Pierre, does the fact that you're taking medication right now that you've stated on the record impact your ability to be truthful here today?
That's a question for you, Mr. Pierre.
Can you repeat the question?
Yes, Mr. Pierre, you've now stated on the record that you just took medication. Does that medication impact your ability to be truthful in your testimony that you're giving here today?
The medication I took is to calm my anxiety and to lower my blood pressure. And that's why I took the medication, because I was not, when I am highly anxious, it's an emotional experience. That does not
Your Honor, I'm
cloud,
going to object as to non-responsive.
that does not cloud my response to be truthful.
Oh, I think maybe you were answering.
Okay,
The
yeah.
question was, does the medication affect your ability to be truthful?
The medication does not impact my truthfulness.
Mr. Pierre, where do you reside right now?
I have the 6071 Mount Vernon Boulevard, Texas, Mount Vernon, Virginia address, because it is still titled under my name and I do get mail there.
Okay. Mr. Pierre, let me ask it a different way. If that judgment, that foreign judgment from Virginia is ever domesticated in Texas, where can you be served with process showing that that judgment has been domesticated so that you can protect your rights to defend against the domestication of that judgment? Where can you be served?
I can be served at 6079 Mount Vernon Boulevard, Lorton, Virginia, 22079. As of today, if that changes, I will notify the court within 30 days of me changing that address.
Thank you, sir. I have no further questions, Your Honor. Just further summation, if I may.
Mr. Pierre, did you have anything else on the motion to dismiss?
Ma'am, I believe.
So maybe I need to be a little more clear. Do you have any other evidence on the motion to dismiss? If not, I'm going to go forward to argument and Mr. Beltran will go and then you can go. So I'm asking if you have either any documentary testimony, any witnesses, anything else that you would like the court to consider on your opposition to this motion to dismiss?
No, ma'am. At this time, I've already clearly stated our contractual agreement was terminated, and the evidence of the decree to sell the property, the sale of the property, was signed under duress, and that's all I have, ma'am.
Thank you. Then, unless you were going to call or someone else or provide additional evidence, Mr. Beltran, you may begin your summation.
Thank you, Your Honor. Just briefly, the defense has changed in this, the defense against the motion. At first it was, there is no contractual agreement. And then when presented with the contractual agreement, it was, well, that contractual agreement shouldn't be, don't pay attention to that. I had to sign it under duress. There's no evidence of that other than his own testimony. But there is evidence that there is a contractual agreement in place that allows Mary Aguilar to take the very actions under contract with Mr. Pierre, and throughout all of this, Mr. Pierre has operated under the assumption that he's the only party to these contracts with Mary Aguilar, when on their face it's very clear his now ex-wife is also a party. And so to claim that he alone has unilateral authority to remove Mary Aguilar from any of the actions that she has taken, including the ones that he very clearly signed, allowing her to do, without Miss Van Wyck or the Virginia court having any say in it, is completely disingenuous at best. In the end, Judge, there is no factual basis for the claims he's bringing against Mary Aguilar. Again, Mr. Pierre has a very valid, compelling argument to make in the sense of this judgment has not been domesticated, so you cannot complete the sale of this home. That is true. But that's not what has happened. The home has not been sold. He's suing the broker he hired to list the property for the sale. He's suing the broker for doing the job he asked her to do. And not only her, also his now ex-wife, who should have a say as to whether Mary Aguilar Felix is doing her job or not. Ultimately, there is no factual basis for the claims. On the legal side, he's brought 3, aiding and abetting a tort that does not exist, negligence, and he has yet to identify the duty that Mary Aguilar owes to him, which can be breached. He's yet to identify what she did to breach any such duty, and he's yet to identify any damages. And finally, he's claiming tortious interference with my property rights when the property remains in his name. The property has not been sold. There is no interference with his property rights. Any clouding of title that he claims, he did it himself a few days ago when he filed the lis pendens in this case. Nobody else has clouded the title to this property. The only thing holding up the sale is the fact that, for whatever reason, neither he nor his ex-wife have filed the Virginia judgment and domesticated it here in Texas. But to sue Mary Aguilar for carrying out the duties that he hired her to do is completely disingenuous. He's forcing her to have to incur costs and defense and attorney's fees to defend herself against claims that are factually false. They are not supported. The timing is wrong. And once confronted with that timing, now the story has changed. Well, ignore it. And so for those reasons, I'm asking the court to grant the motion to dismiss, remove Mary Aguilar from this lawsuit, grant the motion for sanctions in the sums stated in the affidavit, which have not been challenged, and grant what other further relief the court is willing to grant to Mary Aguilar at this time.
Okay. Mr. Pierre?
Ma'am, thank you. Mr. Beltran, thank you. In summary, when Mr. Beltran started, he omitted the fact that Miss Mary was terminated. He brought up 2 points that prior to this meeting, the first one he has not conceded, but today he conceded to the fact that the foreign order does require to be domesticated. However, what Mr. Beltran is explaining is that her actions are legal. Her actions after she was fired is based on the agreement that Sanel and I signed after the fact that she was fired on the 21st. The agreement is signed by the judge, I believe, a couple of days later. So you're seeing the 15th, I testified for the 15th agreement or conversation. And on the 21st, she was fired, or her contractual agreement was terminated, and she continued to act. The other things that Mr. Beltran has addressed, and it helps me to further my case. Aiding and abetting, Texas law mandates that foreign judgment are not unforeseeable. Mary is acting with Miss Claire to sell the property. Mr. Beltran has testified that she actually went out and get a contract to sell the property. That is a forcible action that is not allowed under Texas law. Texas courts have consistently refused to validate actions based on undomesticated orders. This is why I said aiding and abetting. She's aiding Miss Claire to sell the property. There's communications from what I do not have that in my hand, but I believe there are communications with Miss Claire from Mary after she was terminated. Negligence and gross negligence. Mary is a licensed realtor in Texas. Excuse me. One of the reasons that I went with her was the fact that she's had over 30 years of, I believe, please, if I'm wrong, I'm wrong. But I believe she has many years of experience, more than 10. She's a licensed realtor. And the fact that she negligently, after she was fired, continued to act against my interests when I fired her was to protect my rights. But she continues to violate that by acting as if she wanted to hurt me. If I fired you, you shouldn't be acting on my property, but you continue to act. In terms of tortious interference, her deliberate actions after the fact, she continues to collect rent. She went and got a sale contract. Those are action that she's taken against my property rights after I fired her. We do not have an agreement for her to work for me. At this moment, Ms. Van Beek is not here to defend herself. I am here to defend this gross negligence, tortious interference with my property rights, and aiding and abetting. That is what I believe this case is about. It's not frivolous because there exists a law in Texas that requires anyone in Texas not to act on a foreign judgment unless it is domesticated in Texas. Her actions after the 21st shows that she has been negligent in her duty. In terms of the selling of the house, she does not have my authority to work on my behalf. Mr. Beltran has mentioned she has Sanels. Sanel's not here to defend herself. Mr. Beltran had not provided any management contract that Sanel has signed.
Your Honor, I'm going to object on the argument. We're not talking about a management contract. We're talking about the sale of the home. We're talking about the very clearly provided listing agreement for the sale of the home.
I'll overrule that objection at this time. Go ahead, Mr. Pierre.
Ma'am, the contract to sell my property was terminated on the 21st. It was later signed by the judge on the 24th. Mary has no authority to continue to proceed on my behalf with the sale of the property. Therefore, I believe because of her actions against my rights and against Texas law, that this case is not frivolous and it's not malicious against her. Therefore, I kindly request that this case continues and you deny their dismissal of this case. Also, to dismiss their sanction, because as a realtor, Mary should know the law in Texas. I ask you to deny the sanctions, and then I ask that we proceed with this case by setting a calendar control order to where we know what's going to happen next. That's all, ma'am.
Mr. Beltran, did you have anything else?
Your Honor, Exhibit C to the motion is dispositive. Mr. Pierre keeps talking about the judge signed something on the 24th, and the dates are pretty self-evident. Exhibit C, the listing and broker agreement, did not have any signature from a judge that I can see. All I see is Mr. Pierre's initials on each and every page, Mr. Pierre's signature at the end of the document, and Miss Van Wyck's signature at the end of the document. The fact that it's in his face, the evidence that counters his arguments, and he refuses to see what is plainly in front of him and refuses to change his tone about, I fired Mary Aguilar. She has no right to operate. She has no right to represent me in the sale of the home, when 2 days later he signed the very contract that allows her to represent him in the sale of the home, shows how frivolous his claims are. And it does start to become malicious when you refuse to acknowledge the evidence that is right there in front of you, plain as day. And for those reasons, again, Mary Aguilar does not belong in this lawsuit and should be dismissed.
Thank you. That is all the argument the court is going to entertain at this time. I'm going to take a little more time in light of the arguments that were presented here today and some of the evidence, additional evidence that was presented here today, to conform that with your pleadings. I see that we are also set for a scheduling status conference, but obviously in light of the answer now filed by McCarthy Holthus, that might just be premature to do that now. So I'm not going to do any further scheduling other than to reset the scheduling status conference for about 30 days out.
Ma'am?
Now, hold on a second, Mr. Pierre. In addition to that, we will be setting your pending motions, your pending requests, Mr. Pierre, for hearing. I anticipate we can do that on June 25th. June 25th at 9 a.m.
Thank you, ma'am.
And I understand those to be just the ones that were filed in the last couple of days. I'll have to go back and see the actual titles. All right. With that said, it's not going to take me a long time. I would be surprised if you don't have an answer from the court by Friday. It'll probably be sooner. So unless there's anything else, thank you for your time today, and you all are excused.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Hi, Judge. Could I have a minute to
Yeah,
get
let's
ready
take
for you?
a quick break off of YouTube.